Just because you're a U.S. citizen doesn't always mean you can transfer U.S. citizenship to your children. There's a requirement that if a child is born overseas, that you have to be able to transfer that citizenship, you have to have been living in the United States for 5 years, two of which are above the age of 14. If you cannot document that presence, a physical presence in the United States, which a lot of people don't have. They may have been born here and they may have went to elementary school here, but left afterwards and maintained a life overseas. There's really there's two options to get the child citizenship. There may be more exceptions here, and there are the two big ones. One is the N-600K if you plan on continuously living overseas and you have a parent, a grandparent of that child who did have the physical presence requirement in the United States. I did a separate video on that you can check out on our channel. But today I want to talk about the other option, which we typically do, is when the child's a minor and the parent wants to move to the United States and reside here, they apply for a green card for the child. Once the child gets the green card, they move to the United States to live with the parent. They automatically become a U.S. citizen upon the age of 18, before the age of 18. And they could just file for a certificate of citizenship for N-600 to get proof of citizenship. A lot of people don't request this paperwork. It costs a lot of money, but I strongly recommend you do it. We're going to go back to the beginning, but I want to give you an overview of what we're going to talk about today. So again, if you don't naturally pass down citizenship to your child and you can't get a consular record of birth abroad for the child being born abroad or a passport, there still are options for the child. It's essentially the regular green card process for a minor that switches up pretty quickly to citizenship upon residing in the United States with the U.S. citizen parent. This involves filing a Form I-130 petition for alien relative for a minor child. Around recording this, that takes about a year to get approved, unfortunately. You can sometimes do expedites, but it's gotten harder and harder to do so. Once that's approved, then you have to work with the Department of State, first to the National Visa Center, to submit their civil documents and DS-260 background information and form. Now, there's no requirement in these kind of cases to do an affidavit of support. I've had embassies make mistakes thinking it's required, but it's not, because the child is going to become a citizen upon entry into the United States and residing with that U.S. citizen parent. And I'll say why I keep repeating that specific term, just like that at the end of this. There's a reason for it. But they'll become a citizen. There's no requirement for the affidavit of support. So once you submit the Form DS-260 and the civil documents, birth certificates and the like about the child, passport, bio page, and that eventually they'll have an interview at the embassy. The interview should be short because they're minors. Sometimes it may even be waived depending on the age, but you got to work with the embassy to see what the requirements are at that time. And once the visa is issued for the child comes to the United States as long as they're under 18 and resides in the U.S. with the U.S. citizen parent. Then they can file for a passport and certificate of citizenship. Now, one issue that pops up, we see a lot in these cases, is that people come to the United States with the U.S. citizen parent. The child comes with them, and they apply for the passport immediately. And after 2 weeks, they go back to the home country and leave. And what happens that we're seeing now is really dramatic and traumatic. Is 20, 30 years down the line, the U.S. Embassy tries to renew, or they go to renew the passport of a child who's at that point, 30 years old, married, has kids, and they say, you know what? When you came to the United States, you didn't actually reside here. It was almost a vacation. You came with your parent, applied for the passport, left. There's no evidence that you resided with your parent, the citizen parent, in the United States. And they take their passport away, and this person's left there. What to do? Do I need to get a green card, bring back my green card, SB1 visa? And it becomes a whole mess. You might have a petition for a spouse pending, a petition for their children pending. There's a whole thing that becomes really disastrous for these families. So the reason why I make a big deal of that is just if you do this process, you have to come and reside in the United States. The statute and the regulations don't say what residing means, but we say at least be here 6 months. Maybe the child goes to school here, have records of home, all this kind of stuff to show, hey, we were living here, we did reside here, even if we left after that. We did satisfy the requirements of the statute and the regulations for obtaining citizenship based on getting a green card for the minor child in this process. And due to that, I strongly recommend getting Form N-600 Certificate of Citizenship. Unfortunately, it's a costly kind of application to get, more than $1,000, but this will give you a piece of paper, and they're more stringent in giving that piece of paper, the certificate that says you're a citizen, as opposed to the passport office, which sometimes is a little bit more loosey-goosey. But I mean, like out of 1,000 cases, the passport office might approve one more that the USCIS under DHS, Department of Homeland Security, would not add. So it's not loosey-goosey that much, but they're a little bit less stringent than DHS would be most of the time. So you really want to get the more tougher document, the certificate of citizenship. And we've seen cases where people go renew their passport, and in some agencies, in some countries, in some places, they'll say, no, we want to see the certificate, and the person's stranded. What do we do now? Certificate can take many months to get. What are we going to do? So get that. It's worth the investment in your child. But I just wanted to have this to let you know these options do exist to get the child U.S. citizenship, as well as the N-600K if you decide to live overseas and you satisfy that requirements. Please check out our other video on our channel about Form N-600K. But it's a difference than the N-600 I'm speaking about. Both these options exist. There might be some minor other ones, but a bulk of the people wanting to get citizenship for their child that's born overseas and don't satisfy the physical presence requirement will be using these options. I hope that information helped. I'm immigration lawyer John Khosravi. Please schedule time with us. Contact us through our website, jqklaw.com/contact. Fill your name and contact information and brief about your case, and we'll reply with information for scheduling a formal consultation and digging deeper in your case to give you advice on what you can do to be successful in your immigration process. Thank you so much for watching again. I wish you and your family the best.